The next case is Graham v. Uphold. The opinion may be found at 43 Florida Law Weekly D 958A. The opinion was issued by Florida's First District Court of Appeal on April 30th, 2018. In this case, the plaintiff sued the defendant to dissolve a corporation they owned together. After the suit was filed, the defendant elected to purchase the plaintiff's shares and asked the court to determine the fair market value. Accordingly, the proceedings, the case was stayed pursuant to Florida Statutes section 607.1436. After the proceedings had been stayed, the plaintiff then moved for the appointment of a custodian pending the outcome of the litigation. The trial court granted the motion for appointment of a custodian, and the defendant appealed. The first question on appeal was whether the trial court had the statutory authority to appoint a custodian under Florida Statute section 607.1431. The First District Court of Appeal said no, the trial court did not have any authority to appoint a custodian under that statute because there was no pending litigation, because the case had been stayed. The second question on appeal was whether the trial court had any inherent authority to appoint a custodian pending the outcome of the litigation. The first DCA again said no, the trial court did not have any inherent authority to appoint a custodian because the trial court had not made any findings that there had been any waste or any findings that there was any serious risk of loss pending the outcome of the litigation. Accordingly, the appellate court reversed the order appointing a custodian and remanded the case for further proceedings.